Most people in Virginia believe that if they're over 21 and only growing 4 cannabis plants at home, they're fully protected by the law. That assumption sounds reasonable, and on paper, it is. But this is where outcomes quietly change, because legality under Virginia law does not always mean compliance and enforcement. And that distinction is where cases, complaints, and penalties actually begin. Earlier I mentioned that growing 4 plants sounds straightforward. It is. It is, until visibility, tagging, household definitions, or landlord authority enters the picture. And we'll come back to why that matters more than most people realize. Here's the counterintuitive legal fact or misconception. Virginia law does allow limited home cultivation. That's true. But the statute does not protect you from every consequence connected to that cultivation. It protects you from one specific charge, unlawful possession tied to plant count. Everything else operates in parallel. That sounds subtle, but legally it's a major distinction. Because enforcement rarely turns on a single statute, it turns on how multiple rules interact in the real world. And this is where most people stop learning, and where problems start. Let's challenge a belief you likely hold. A lot of Virginians believe the rule is simple: 4 plants per household, tag them, keep them out of sight, and you're fine. That belief feels complete. It feels safe. But the law doesn't ask whether you followed a rule. Enforcement asks whether you followed all applicable standards, including ones that live outside cannabis law entirely. Housing law, local nuisance enforcement, fire code, lease agreements, and, well, enforcement discretion. That belief, that knowing the rule equals avoiding the consequence, is the belief that gets tested later. Welcome to Norfolk, Virginia Cannabis Hub, where we focus on Virginia-specific cannabis law, local governance, and regulatory clarity, so residents, business owners, and communities understand what the law actually says, not just what headlines suggest. Today we're looking at Virginia cannabis home cultivation law, what it allows, where it becomes conditional, and why enforcement outcomes often surprise people who thought they were compliant. This is not a cultivation tutorial. We're not discussing how to grow cannabis. We're focusing strictly on legality, regulatory interpretation, and enforcement reality under Virginia law. And as always, this is educational, documentary, and compliance-focused. Here's the context. Virginia legalized limited home cultivation as part of its broader cannabis reform framework. The goal was narrow: reduce criminal penalties for personal possession and provide adults a lawful way to grow small amounts for personal use. But the law evolved alongside hemp regulation, medical cannabis, zoning authority, and landlord-tenant law. That layered evolution is why confusion is so common. Different agencies regulate different parts of the outcome, and they don't always speak in one voice. So while the Cannabis Control Authority provides guidance, enforcement often happens elsewhere. That's not a flaw in the law, it's how Virginia governance works. And that leads us directly into the statutory framework, where clarity exists, but only up to a point. Here's the legal explanation. Virginia Code Section April 1, 1101 allows individuals 21 and older to cultivate up to 4 cannabis plants per household, not per person, for personal use. A household includes everyone living at the residence, related or not. Each plant must be tagged with the grower's name, a driver's license or ID number, and a statement that the plant is grown for personal use as authorized by law. Plants must not be visible from a public way and must not be accessible to anyone under 21. That all sounds clear. Legally true, yet operationally misleading. Because the statute answers how many plants are allowed. It does not answer how enforcement evaluates visibility, accessibility, household control, or property authority. And it does not override private restrictions like lease agreements. This is where surface-level legality and real-world outcomes begin to diverge. How enforcement works. Home cultivation is not proactively inspected by the Cannabis Control Authority. Enforcement usually begins through a complaint, often unrelated to cannabis itself. Odor complaints. Fire safety issues. Lease disputes. or visibility concerns raised by neighbors or property managers. Local law enforcement, code enforcement, or housing authorities typically lead these investigations. And here's the key point: lab reports, grower intent, and even statutory compliance do not automatically control the outcome. Visibility from a public way is assessed by human observation. Accessibility is interpreted based on physical access, not intent. And plant tags, while required, do not cure violations outside the cannabis statute. This is where enforcement changes the outcome. Who this affects? Consumers are affected because compliance depends on more than plant count. Retailers are affected indirectly, as misinformation circulates about what home cultivation legally protects. Local governments are affected because nuisance, zoning, and safety enforcement falls on their shoulders. And the medical cannabis framework operates separately. Medical authorization does not expand home cultivation rights, nor does it override household limits or landlord authority. Each group touches the law differently, and that's where misunderstanding spreads. Why this matters? This matters for public safety, because electrical, fire, and access risks are regulated regardless of cannabis legality. It matters for regulatory clarity, because incomplete understanding creates enforcement friction. It matters financially, because civil penalties, lease violations, or code enforcement actions can occur even when cannabis possession itself is lawful. And long-term, it shapes how Virginia adjusts its cannabis policy, based not on statutes, but on outcomes. Now, this is the point where we need to slow down and reframe what you think you understand. Up to now, we've talked about what the law says. But this is where cases actually turn: how the law is applied when multiple rules overlap. Because compliance with cannabis law does not immunize you from consequences triggered by something adjacent. And this is where that initial assumption, that 4 plants equals safety, starts to break down in practice. Let's walk through a realistic scenario. Here's a scenario. Earlier I mentioned that legality does not always mean compliance. Now let's return to that. Imagine a Norfolk renter, over 21, growing 4 tagged plants indoors. The plants aren't visible from outside. On paper, they're compliant. But the lease prohibits any cultivation activity. A maintenance visit leads to a report, not for cannabis possession, but for lease violation and electrical modifications. Code enforcement gets involved. No criminal charge is filed under cannabis law. But the tenant faces lease termination and civil consequences. Now contrast that with a homeowner following the same cannabis rules, but with unsecured access to minors. Same statute. Same plant count. Very different outcome. This is where that issue becomes clear. The law answered one question. Enforcement answered another. Here's what to watch next. In the next video, we're going to examine how landlord authority and private contracts interact with Virginia cannabis law, and why legalization does not override property rights. Here's a question to think about. If cannabis is legal to grow under state law, but prohibited under private agreement, which rule actually controls the outcome? Drop your thoughts in the comments, and let us know what Virginia cannabis law questions you want covered next. Like, comment, and subscribe to stay inside the compliance conversation, and join the Norfolk City Cannabis Community for deeper, respectful discussion.